A teenage boy sits under fluorescent lights, in a small room that doesn't look like a movie set. Two adults ask him questions in calm voices. There's no shouting in the version most people remember. No dramatic slam on a table. Just a steady stream of prompts, pauses, and gentle corrections. And then, at one point, after the boy has agreed with a version of events that would change his life forever, he asks something that stops a lot of viewers cold. He asks if he'll make it back to school that afternoon, in time to turn in a project. That detail matters because it captures the central tension in Brendan Dassey's case. Not just what he said, but what he understood. Not just the words on the tape, but the mind behind them. And the hardest part is this. The legal system has already answered the question of whether his confession was voluntary. A jury convicted him. Appeals ran for years. And yet, public debate still burns, because many people are not asking the same question the courts were asking. So tonight, we're going to do something careful. We're going to separate what's confirmed in court records from what's alleged by either side, and from what remains unknown to the public. We're going to talk about Teresa Halbach, the woman at the center of this tragedy, without turning her into a footnote. And we're going to walk, step by step, through how a 16-year-old ended up serving a life sentence. Here's the main question that will guide this entire story. How did a juvenile confession become powerful enough to withstand years of legal challenges, even as experts, advocates, and millions of viewers questioned whether it should have been trusted in the first place? And I'm going to promise you something specific. If you stay with me to the end, I'll bring you to the moment that best explains why this case remains so divisive. A federal appeals court split decision that didn't simply argue about Brendan's words. It argued about what a federal court is even allowed to do when it believes a state court got it wrong. That split is the hinge on which the modern chapter of this case turns. If you value careful true crime reporting that avoids rumor, respects victims, and tells you what's known versus what's claimed, consider subscribing now. It helps this channel keep making deep dives like this, and it makes sure you don't miss the payoff we're building to. The legal turning point that changed Brendan Dassey's chances, and why it still shapes juvenile confession debates today. Before we ever talk about Brendan Dassey, we have to talk about Teresa Halbach, because every argument about interrogations and court standards can accidentally do something ugly. It can erase the person who lost her life. Teresa Halbach was a young woman in Wisconsin who worked as a photographer. People who knew her have described her as driven, kind, and close to her family, someone building a life with plans, routines, responsibilities, and relationships that mattered. However you feel about the trials that followed, this part is not up for debate. She was a real person, and her absence left a hole that didn't close after the verdict. The confirmed timeline begins in the fall of 2005. Teresa Halbach disappears after going to take photos for an auto trader appointment in the Manitowoc County area. What happens next, according to investigators and prosecutors, becomes a rapid acceleration from missing person to homicide investigation. And from the beginning, the story is tied to another name that most people know first, Steven Avery. Steven Avery was Teresa's last known appointment on October 31st, 2005, connected to the Avery family salvage yard. Avery would later be convicted for Teresa Halbach's murder. Brendan Dassey, Avery's nephew, would also be convicted, based largely on his confession. And already, one of the most important clarity anchors in this case is this. There are two separate trials, two separate defendants, and two separate bodies of evidence. Public conversations often mash them together, but in court they were distinct. That distinction will matter later, when we talk about why some evidence appeared in one case and not the other, and why some viewers feel the documentary blurred those lines. Now, in the early days of any investigation like this, there's an almost unavoidable pressure cooker effect. Families want answers. Communities want safety. Investigators want to find the truth. And when the investigation locks onto a suspect, every subsequent decision can bend toward that conclusion, sometimes for good reasons, sometimes in ways that later look like tunnel vision. In this case, the suspicion zeroed in on Steven Avery. And once that happened, the circle widened. It widened to include people around him. It widened to include the salvage yard. And it widened to include a teenager who, by most accounts, was quiet, socially awkward, and in special education classes. That teenager was Brendan Dassey. Let's pause here, because I want your perspective early, before we get pulled by the gravity of what happened next. Do you believe police should ever interrogate a 16-year-old about a serious felony without a lawyer physically present? Not read the rights, in theory, actually present in the room. Drop your answer in the comments, because as we move through this story, you may find your answer changing. Here's what is confirmed in court records about the confession that defined Brendan Dassey's case. In early 2006, Brendan Dassey was interviewed by law enforcement multiple times. Two dates are especially important: February 27th and March 1st. The March 1st interview is the one described by the 7th Circuit as the most incriminating evidence at trial. According to the banc opinion, the trial judge found that Brendan knew he could stop answering questions and could leave at any time on February 27th, and that on March 1st both Brendan and his mother consented to the interview. The judge also found that he was given Miranda warnings and understood them sufficiently. The same decision notes that the interrogation occurred during school hours in what the court described as a comfortable setting, with access to breaks, and without physical coercion or overt threats. And then we collide with the part that's so difficult to hold in your head at once, because that same court opinion also acknowledges factors that could support the idea the confession was not voluntary. Brendan's youth, limited intellectual ability, some suggestive questioning, broad assurances that honesty would help him, and inconsistencies in his confession. It even highlights how, after confessing to acts that would lead to a life sentence, Brendan asked whether he would be back at school that afternoon in time to turn in a project. That's the kind of detail that doesn't neatly fit either side's narrative. If you believe Brendan was coerced, it sounds like proof that he didn't grasp the gravity of what was happening. If you believe the confession was truthful, it might sound like a teenager compartmentalizing or dissociating in a moment of severe stress. Either way, it's a vivid sign that youth doesn't process high-stakes situations the way adults do. Now let's separate two different kinds of questions that often get confused. Question 1 is psychological and practical. Was Brendan's confession reliable? Did it match independent evidence? Did it include details only the perpetrator would know? Did it shift in response to prompting? Question 2 is legal. Was the confession voluntary under the Constitution? And did the state courts unreasonably apply clearly established federal law when they ruled it voluntary? Those are not the same question. And that gap, the gap between reliable and legally admissible, is one of the reasons this case doesn't die. Brendan Dassey went to trial. A jury convicted him on charges including homicide and other serious offenses. The banc opinion states that the March 1st confession was the most incriminating evidence at trial, and that he was sentenced to life in prison in August 2007. Here's what's alleged or debated. Brendan has maintained at different times that his confession was coerced or untrue. His defense has argued that he was especially vulnerable, a juvenile in special education, with limited intellectual ability, subjected to leading questions and psychological tactics that can produce compliant statements. The state's position has been that the confession was voluntary and that the courts reviewing it should defer to the state court's findings. That's the courtroom framing. But outside the courtroom, millions of people were introduced to the case through documentary footage. And that created another layer, the viewer's trial, where people feel like they watched the evidence with their own eyes. Here's what I want to do carefully. I'm not going to tell you what to believe. I'm going to show you the structural pressure points, places where the system either protects juveniles or fails them, depending on your view. And then I'm going to bring you to the legal turning point that explains why Brendan's case ended where it did. To do that, we need to zoom in on the interrogation itself, not with sensational edits, but with the kind of slow attention it deserves. In many interrogations, especially with vulnerable suspects, the most influential tactics aren't the loud ones. They're the soft ones. They're the repeated assurances that honesty will help. The subtle implication that the worst thing is to hold back. The repeated correction of answers that don't match what the interrogators think happened. Research on false confessions has shown that certain conditions increase risk. Youth, cognitive limitations, high suggestibility, and interrogation techniques that create psychological pressure. Organizations like the Innocence Project have long emphasized that false confessions can and do happen, and that reforms, especially for juveniles, are needed in many jurisdictions. That doesn't automatically mean Brendan's confession was false, but it does mean we need to be honest about the risk profile. Now, a key detail in the banc decision is that the court said both sides stipulated Brendan was not in custody at the time he went with officers and made admissions. That matters because the law treats custodial interrogations differently. But practical reality matters too. Not in custody on paper can still feel like, I have to comply in a teenager's body. Imagine being 16. Imagine adults with authority telling you they need your help. Imagine not fully understanding what party to a crime means, or what a life sentence really looks like, or how the next hour can take the next 40 years. Then consider the way people respond under pressure when they want the discomfort to end. Some people fight, some people shut down, and some people comply. One of the most debated aspects of Brendan's interrogation is how often interrogators suggested details, returned to topics when they weren't satisfied, and framed honesty as a pathway to relief. And here's where we need a clarity anchor. The state courts, and later, the banc majority, did not necessarily say the interrogation was perfect. They said, in essence, that the state court's decision that the confession was voluntary was not so unreasonable that a federal court could overturn it under the strict habeas standard. That's a technical statement with enormous consequences, because it means you could believe, personally, that Brendan's confession should have been suppressed, and still accept that federal law limits what federal judges can do after a state conviction becomes final. That's not satisfying. It's not emotional closure, but it's the legal reality that will become the heart of our midpoint twist. Before we get there, we have to cover something else that quietly shapes public opinion: the role of corroboration. In public debates, a common question is, where was the forensic evidence tying Brendan to the crime scene? Why did the confession feel like the main pillar? How much did it match independent facts versus being shaped by prompts? Court opinions and trial records include extensive discussion of evidence, but what many viewers remember is this: the confession is the loudest thing. It's vivid, it's hard to unhear. And once a confession is in, it can dominate a jury's mind. There's research suggesting that confession evidence can override other evidence, even when reliability is uncertain. That's one reason false confession scholarship matters so much in cases like this. Confessions carry a psychological weight that's hard to neutralize. Now, as we move through the next phase, I want to keep Teresa Halbach in frame, because legal debates can turn a murder into an abstract argument about rights and standards. But at the center of this case is a woman whose family had to sit through years of proceedings, years of headlines, years of renewed attention, every time a new appeal or documentary episode dropped. Whatever you think about Brendan Dassey's guilt, Teresa Halbach deserved a full life. Her family deserved peace. And it's one of the tragedies of cases that become cultural phenomena. Peace becomes almost impossible. Now let's step into the courtroom timeline, because this is where the story changes shape. After Brendan's conviction and sentencing, he pursued appeals in state court. The Wisconsin Court of Appeals affirmed his convictions, finding his confession voluntary, and later the Wisconsin Supreme Court denied review, according to the banc opinion. Then comes a crucial transition: federal habeas corpus. Habeas is not a new trial. It's not a redo. It's a narrow path where a federal court can grant relief if a state court's decision was contrary to, or an unreasonable application of, clearly established federal law, or based on an unreasonable determination of the facts. And in 2014, Brendan filed a federal habeas petition. Here's where the story hits its first major reframe. In a detailed opinion, a federal court granted habeas relief, finding that false promises of leniency were indeed made, and that Brendan's March 1st confession was not voluntary. A divided panel of the Seventh Circuit affirmed. For a moment, the case looked like it might break open. If you watch the documentary, you may remember the sense of nearing a cliff's edge, the idea that Brendan could be released unless the state retried him. That moment is one reason the case became more than a local tragedy. It became, for many, a symbol of what happens when a juvenile confession becomes the engine of a conviction. And now I want to ask you another question, tied to this exact moment. When you think about justice, what matters more to you, reaching the correct outcome in a single case, or maintaining a legal system that limits federal courts from overturning state convictions, except in extreme circumstances? There's no easy answer. But your instinct here will shape how you feel about what comes next. Because what comes next is the pivot, the hinge, the legal event that, in many ways, sealed Brendan's fate. The Seventh Circuit granted rehearing en banc. That means the full court, not just a 3-judge panel, would reconsider. And in December 2017, the en banc court reversed. The majority held that the state court's finding that Brendan's confession was voluntary was not beyond fair debate, and therefore it was not unreasonable under the deferential AEDPA standard. The habeas relief was reversed, and the petition was ordered dismissed. In plain English, even if federal judges thought the confession was problematic, the majority said the law did not allow them to call the state court's decision unreasonable enough to overturn. This is the moment where the case stops being only about Brendan's interrogation and becomes about the architecture of American post-conviction review. And if you're still with me, this is where I want to reward that attention with a micro payoff. The en banc opinion does something unusual in public debates. It acknowledges both sides' strongest points. It lists the vulnerabilities: youth, intellectual limitations, being alone with police, broad assurances of leniency, and suggestive questioning. Then it lists the counterpoints: the setting, the breaks, the calm tone, the absence of physical threats, the fact he was given Miranda warnings, and the finding that no explicit promises were made. It's almost as if the court is saying, yes, this is uncomfortable, but discomfort is not the same as constitutional involuntariness under the standard we are required to apply. Now, right around here, because we're about halfway through this long walk, I'm going to make one small request, and only once. If this careful breakdown is helping you separate documentary memory from legal reality, a quick like tells me to keep making these deep dive, court record based episodes. Now let's keep going, because we still haven't reached the Supreme Court moment, and we haven't closed the biggest loop: why so many experts and advocates still cite this case as a warning sign about juveniles and interrogations. After the banc loss, Brendan's legal team petitioned the U.S. Supreme Court. The docket shows multiple amicus briefs were filed, including by organizations and experts who argued that youth and developmental vulnerability must be taken seriously in voluntariness analysis. The American Psychological Association noted, in its public materials about the case, that the Supreme Court denied certiorari on June 25, 2018. And that denial is a quiet kind of ending, not a courtroom finale, not a dramatic last argument, just a procedural line that means the court will not take the case. It's important to be clear about what a cert denial does and does not mean. A denial is not a ruling on the merits. It does not mean the Supreme Court agrees with the lower court. It means the court chose not to review. The practical effect, though, is enormous. It leaves the lower court decision standing. And for Brendan Dassey, it meant the federal path narrowed even further. Now let's pull back, because the most ethical way to cover this case is to resist the temptation to treat it like a scoreboard. This isn't sports. It isn't Team Avery versus Team Prosecution. And it isn't a documentary fandom. It's a murder case. Teresa Halbach is still gone. 2 men are in prison. One of them was a juvenile when he confessed. And every year that passes is a year that can't be given back, no matter how the system answers the questions. So what are the questions we can responsibly ask, without pretending we can do what a jury did or what a court did? We can ask how juvenile interrogations should work. We can ask what safeguards should be mandatory, not optional. We can ask why voluntary is treated as a binary when human behavior under pressure is not. And we can ask what the Brendan Dassey case teaches us about how the public consumes true crime. Because another loop in this story isn't legal. It's cultural. Making a Murderer introduced millions of people to the idea that editing, framing, and narrative pacing can make a viewer feel like they personally witnessed injustice. And sometimes the feeling aligns with the record. Sometimes it doesn't. Sometimes it's a mix. The ethical question for creators, and for viewers, is, how do we hold empathy without becoming certain in the absence of full evidence? Here's a clear truth about the format. Documentaries are not court transcripts. Even when they include real footage, selection changes perception. That doesn't make them dishonest by default. It means viewers should treat them as a lens, not a verdict. If you watched Making a Murderer, what moment shaped your opinion most? The interrogation footage, the trial outcomes, the idea of conflicts of interest, or something else entirely? I'm genuinely curious, and I read those comments closely because they reveal how different parts of the same story land on different people. Now I want to get more specific about the interrogation dynamics, because it's where the debate becomes concrete. In many disputed confession cases, one of the key issues is contamination. Contamination doesn't require physical force. It can happen when interrogators feed details, intentionally or unintentionally, so that a suspect's later statements appear to have inside knowledge. That's why critics scrutinize leading questions, repeated correction, and the "we already know what happened" posture. The banc opinion acknowledges that portions included leading and suggestive questions, and that when investigators were not satisfied with what Brendan told them, they pressed with follow-ups that sometimes made him seem to guess. That's not an accusation from a blogger. That's language within the court's own summary. But the court's bottom line was not, "This is ideal." It was, "This was not so coercive that a state court's opposite conclusion is unreasonable under AEDPA." So if you feel whiplash, that's because you're trying to fit a human event into a legal category. Now, here's where we should be honest about what we cannot know from the outside. We do not have direct access, as members of the public, to every private moment of Brendan Dassey's mental state. We cannot climb inside his head on March 1, 2006. We can watch the tape, read summaries, and consult experts, but certainty is not ethical here. What we can do is ask what safeguards reduce the risk of getting it wrong. One safeguard is counsel. Another is the presence of a parent who is not merely in the building, but actively protecting the child's interests, and who understands what is happening. Another safeguard is recording entire interrogations, start to finish, so courts and juries can see the full context, not just snippets. And another safeguard is limiting deceptive tactics with minors, because juveniles are more likely to take authority at face value, more likely to interpret minimization as promise, and more likely to make short-term choices that harm them long-term. Advocacy organizations have pushed for these reforms for years. The Innocence Project, for example, highlights the role false confessions can play in wrongful convictions and supports reforms including limitations on deception with juveniles. Again, this does not prove Brendan's confession was false, but it explains why his case became a touchstone. Now let's talk about a part of the case that often gets lost in the debate, the legal definition of voluntary. In everyday English, voluntary means I chose it freely. In constitutional law, voluntariness is judged under a totality of the circumstances test, the suspect's characteristics balanced against police pressures. That sounds flexible, but in habeas review, flexibility becomes constrained by deference. The federal court is not asking, "What would we decide?" It's asking, "Was the state court's decision unreasonable in light of clearly established Supreme Court precedent?" That difference is why the banc majority could write a decision acknowledging troubling factors, but still deny relief. And that's also why the dissent, because there was a dissent, could argue forcefully that the confession was not voluntary in any meaningful sense, and that the state court's factual findings about promises and leniency were unreasonable. If you've ever wondered how intelligent judges can look at the same record and come away with opposite conclusions, this is your answer. Law is not only about facts. It's about the standard of review. It's about what you are allowed to do with those facts. Now, let's close another loop. What happens after the Supreme Court denial? Brendan Dassey remained incarcerated. Publicly available materials and multiple sources indicate he is still in Wisconsin custody, and advocacy sites continue to publicize ways to contact him by mail. But rather than turn this into "where is he now" content, I want to focus on the deeper now of the case, what it changed and what it didn't. The cultural impact was immediate. The legal impact was slower and uneven. Some states and jurisdictions have moved toward reforms around juvenile interrogations, including restrictions on deception, mandatory recording, and developmentally informed practices. Other jurisdictions have not, and even where reforms exist, they are not always retroactive, and they do not automatically reopen old cases. So Brendan's case sits in a painful place. It is widely cited in discussions of juvenile justice reform, yet it did not become a vehicle for a Supreme Court ruling that would set a new national standard. For people who believe Brendan is innocent, that feels like a system failure. For people who believe he was involved, it feels like the system worked. And for many, it feels like something in between, that the system might have reached the correct outcome, but used a method that we should never be comfortable with. Now, I'm going to say something that may feel uncomfortable, but it's important. True crime stories often teach viewers to crave coherence. We want a clean narrative, good people, bad people, clear motives, clear evidence, a final reveal. Real cases don't always offer that, and when they don't, we become vulnerable to the storyteller who offers coherence first and truth second. This is why I'm being so careful to separate confirmed, alleged, and unknown, because the second we start laundering speculation into certainty, we harm the very thing we claim to care about, justice. So let's take inventory out loud as we approach the final act. Here's what we know. Brendan Dassey was 16 when he gave the confession that became the most incriminating evidence at his trial. He later recanted. State courts found the confession voluntary. A federal judge granted habeas relief, and a Seventh Circuit panel affirmed. The full Seventh Circuit reversed en banc, citing APA deference. The Supreme Court denied certiorari in June 2018. Here's what is alleged or debated: whether the confession was contaminated by suggestion, whether Brendan understood his rights, whether the psychological pressure in that room overcame his ability to make a rational choice, whether law enforcement implicitly promised leniency, even if they did not explicitly do so. Here's what we cannot know with certainty from the outside. What, if anything, Brendan did on October 31st, 2005 beyond what was proven at trial. What was inside his mind when he agreed with investigators' narrative, and whether a different interrogation method would have produced a different outcome. Now I want to open one final comment prompt, because this is where your judgment matters most. What evidence would you personally need before you trusted a confession as the central pillar of a conviction, especially when the person confessing is a minor? Do you need corroboration on multiple details? Do you need forensic support? Do you need a lawyer present? Tell me your threshold. Now, the peak of this story, the part that lands hardest, if you let it, is not the tape itself. It's what the tape represents. A juvenile, questioned by adults, becomes a source of proof strong enough to shape a life sentence. And even when multiple federal judges believed the confession crossed a constitutional line, the architecture of habeas review meant that belief could be legally irrelevant. This is the part that lingers, because it forces you to confront two truths at once. Truth 1, a confession can be powerful evidence. Truth 2, a confession can be profoundly unreliable, especially with juveniles, especially under suggestive conditions. A justice system has to be able to tell the difference. And the history of wrongful convictions shows that we are not always good at it. In research on confessions, scholars like Saul Kassan have written about how interrogation is a social influence process, and how certain tactics and vulnerabilities can increase the risk of false admissions. Advocacy organizations point out that reforms are often necessary precisely because human psychology is predictable under pressure. You don't have to pick a side in Brendan's case to accept that broader lesson. You can accept it as a safeguard principle, build systems that reduce the risk of catastrophic error. Now, as we close, I want to return to Teresa Halbach. Because what does it mean to learn from a case like this? It means remembering that a person died and that her life cannot be restored by any argument. It means acknowledging that her family has carried grief through decades of renewed attention, litigation in the court of public opinion, and the strange cultural afterlife of their loved one's name. And it means, if we're honest, sitting with the possibility that the system can produce outcomes that feel final without feeling satisfying. The Supreme Court denial in 2018 didn't create closure. It created an endpoint in one legal sense. But morally and culturally, this case doesn't have a clean ending. For Brendan Dassey, the consequences are lived daily. For Teresa Halbach, the loss is permanent. For the public, the case became a symbol, sometimes of wrongful conviction, sometimes of the danger of documentaries shaping perception, sometimes of how hard it is to protect juveniles inside an adult system. And for anyone who cares about justice, the lasting question is not only what happened, but how should we treat a child when the stakes are life and death? Should a child ever be alone in that room? Should voluntary mean more than the absence of overt threats? Should the law allow an outcome to stand because it's not beyond fair debate, even if serious doubt remains? Those are the questions that outlive this case. If you've made it this far, thank you for taking the slow route, because the slow route is the only ethical route for stories like this. If you want more long-form investigations that prioritize court records, victim respect, and honest uncertainty over hype, you can subscribe. And if you'd like a related deep dive next, I can cover how confession science has reshaped modern interrogation practices and why some jurisdictions have moved away from older techniques without sensationalizing a single victim's story to do it.